Good afternoon, everyone. I am Ajay Verma, advocate here, and we are again here with another series and very important topic today on revisiting the rules of evidence, criminal and civil jurisdiction. This topic is certainly a very vast topic and it requires a big series for this. However, we have a very wonderful resource person, one of the best criminal lawyer in India, Mr. Sidharth Luthra, sir, former Additional Solicitor General of India, who is also a visiting faculty professor of Northumbria University at Newcastle, United Kingdom. For those who are joining in this session from Sri Lanka and Myanmar, it is my responsible duty to inform you that the jurisdiction, common law jurisdiction, do share a lot of similarity with Indian jurisdiction. So please, there are certain announcements I have for you. Please mute all your mics, disable your videos, do not interrupt in between this when the resource person is speaking. Your questions would be taken after at the question answer session. Please send those questions in chat and I will put it to the respected resource person. And without making you wait, I am requesting, sir, please start the session.
Good afternoon and thank you all for being here. As Mr. Verma has rightly said, it's a very vast subject, and when the subject is so vast, one of the disadvantages is where do you begin, where do you end, and is it possible to even consider concluding on a given day? Now that is that's a chance you take when you choose a topic. And since I put my neck in the noose when I discuss this topic with Ajay, I will try and deal with certain aspects of it, not purely academic, not in the flow of the Act or the Code, or the Evidence Act, but really almost like a practitioner's hand guide to understanding or dealing with evidence. I must share with those of you who are here, I started my career as a lawyer practicing civil law. And though Mr. Verma called me a criminal lawyer, I will say I'm a lawyer practicing criminal law. Calling somebody a criminal lawyer can be a little troublesome, can't it? So let's have a little understanding as to what we're dealing with today. In most of the Commonwealth countries, the principles of evidence were culled out by Great Britain and put in the Evidence Act. There are variations of this in other common law countries, Commonwealth countries. They've adapted. So the Evidence Act comes in, it culls in hundreds of years of English jurisprudence on evidence and summarizes principles of evidence. In England, they tried to codify the law of evidence in 1984, 89 they amended it and so on and so forth, in what is called the Police and Criminal Evidence Act. They tried hard, but I don't think they have achieved the clarity of the Indian Evidence Act, which even after 150 years, it's an 1872 Act, it still remains evergreen, and it's a beautiful piece of writing. The Evidence Act applies to both civil and criminal proceedings. Of course, it applies to judicial proceedings and not for arbitrators. And evidence is categorized into, there are different categories, the main amongst them being oral, that's section 59 and 60, and documents, that's section 61 to 65. And now, of course, we have electronic evidence, which is another interesting area, 65A and 65B. And well, I'm going to deal with that a little later. And there's a flurry of judgments and precedents in the last few years. It's like one step forward, two steps backward, which has been going on. And the law is still developing and the judgment is not yet out. Apart from this, you have in the Act is categorized into three parts. The first part, sections 5 to 55, deal with relevancy of facts. How are things relevant? How are they to be considered? The second part of the Act, sections 56 to 100, deal with how proof is to be done, how things are to be proved. And the third part is the production and effective evidence, that's section 101 to 167, which includes things such as what is admissible, what is not admissible, and even looks at how evidence is to be done, how cross-examination is to be done, the role of a judge. So that's a vast body, and we'll deal. In civil cases now, the old rule has been done away with. In UK, you have evidence on that. In civil cases, you have affidavits, which have been permissible now in civil suits for quite a long time. You have commissions, apart from, but cross-examination is still done in court. And in criminal cases, you have oral evidence in court. Some exceptions, such as the Negotiable Instruments Act, which allow affidavits. Otherwise, affidavits are not treated as evidence. And thirdly, you have affidavits for formal witnesses in criminal cases, and commissions are also permissible. The fact that video conferencing can be done was decided and settled in 2003 in Dr. Praful Desai's case, so that's now acceptable to Indian law. The distinction between civil and criminal cases is that civil cases are decided on what we call preponderance of probability. Whereas criminal cases, the test is of proof beyond reasonable doubt, but this doubt has to be, the doubts can't be something which are imaginary, it has to be reasonable doubt. That's been explained in a number of decisions, and I'm not going to dwell on that too much. But please do remember that these are very important principles which we need to deal with when we appreciate Evidence Act. Of course, when you come to proving defense witnesses in a criminal case, the preponderance of probabilities test applies. Though frankly, in practical terms, judges don't really deal with or are very sensitive to defense witnesses. In most cases, there's always an unfortunate suspicion regarding defense witnesses as a practitioner's experience, I can tell you. And in some legislations, such as POCSO, keeping in view the presumptions and the manner in which the legislation has been framed, even the burden of proof, that is, proof beyond reasonable doubt, is the test of innocence of a practitioner. Now, therefore, Evidence Act must not be seen independent of the substantive statutes, as also independent, and it has to be seen in conjunction with the laws, whether it be civil procedure, criminal procedure, because the Evidence Act deals with the aspect of evidence, but there are certain rules and norms in the CRPC and CPC which become very limited. As I said, of affidavits in criminal cases for formal witnesses, that's a test of CRPC. You won't find the Evidence Act. There are also two important issues. There are in the evidence, section 4 is a very important provision. It deals with presumptions of fact, where the word may presume is used. It deals with presumptions of law, where we use the shall presume normally. And then there is the term conclusive proof, which is defined there, which is very important. So one fact is conclusive proof of another, then you can't have evidence to disprove it. Now, what are these kind of examples? So, one of the presumptions of fact is section 115. For example, illustrate the number of illustrations, you have them. Then you have presumptions regarding documents and old documents and records, section 79 to 98. And then you have presumptions. As I said, these are as a rebuttable presumption, where it's a conclusive proof, then will be an irrebuttable presumption. So, by way of example, if you just look at it a little carefully, so section 111A uses the term shall, whereas 113B, which deals with equality, uses the word may. 113B again uses the word shall, this deals with dowry death, and 114A deals with rape offences, which again uses the word shall. 112 is a very interesting provision in the Evidence Act, and when I talked about conclusive proof, that's what we mean. So conclusive proof becomes interesting because, let's say a child is born within 280 days of marriage, or a child 180 days of marriage, or during the course of marriage. the legitimacy of that child, there is conclusive proof of the legitimacy of that child. That's what the provision says. Of course, you can always try and prove adultery and try and get out of it, but otherwise, that's the principle of evidence against you or in your favor, as the case may be. So these presumptions are very important because, as we will see, increasingly in legislation, look at all the fiscal legislations. Look at legislations, for example, PMLA. Look at the legislations on Income Tax or Black Money Act. All of these legislations, Customs Act, DRI, the Customs Act, Excise Act, all of these legislations use presumptions. And invariably, there is a certain test set up, and if that test is met, then there is going to be a presumption which is going to be read against you. Whether it is rebuttable or not varies from statute to statute, and that is what a lot of investigating agencies and entities use against you. For example, in the context of the customs law, statements before a customs officer are admissible because they are not police officers. Now, if this statement is admissible and there's a presumption, you as an accused have or a person facing proceedings has a very high test to meet. So that's one part which I wanted to just place with you. Then I want to talk about relevancy. Now, relevancy relates to, because relevancy is this large section from 5 onwards of the Evidence Act, large part 1, which deals with what are facts in issue. In civil cases, it's quite simple. We frame issues. So issues of fact are the facts in issue that have to be established. But relevancy must not be equated with admissibility. Admissibility and relevancy is a term which you will find in judgments also. Judges say admissible and relevant or relevant and admissible, but they are two distinct concepts. That's been explained in a beautiful decision, and I'll give you the citation. It's Ram Bihari Yadav, 1998, 4 SCC 517. So there may be facts which are not admissible but are relevant. For example, a communication between spouses during marriage, or privileged communications between a lawyer and his client. And there will be facts which are admissible but may not be relevant. So when you cross-examine a person, and you're cross-examining the person, let's say on his recollection, testing the veracity, testing his memory, testing if there's an accident, testing the speed, testing whether it was night or day, or testing his remembrance of how many places of whether he had a meal or did not have a meal. You're testing the individual's veracity, the witness's veracity, and these are not relevant, but all these facts will become admissible to question the veracity of a person. And lastly, you have what is called the probative value. What is the weight a judge is going to give to what is proved? Now, on probative value, you will see that there are a large number of bodies of decisions which have come about explaining that some things are treated as corroborative evidence, some things are treated as substantive evidence, and all of the weight attached is settled down. And all of this has been arisen through precedents and through English law, which have now been distilled into Indian law and read in the context of the Indian Evidence Act. No discussion of evidence can be complete without an understanding as to the legality of evidence. So how do you deal with evidence which is obtained illegally? Let's say you get a document illegally. Let's say a police officer or a person gets hold of correspondence which is very material illegally. I'll give you an interesting decision. An interesting anecdote, in fact, when I was studying way back in the 90s in England, one of my professors used to told us one day of the WM Act. So we were intrigued. I said, what is this WM Act, Professor? He said, young Mr. Luthra, this is the Ways Act. So of course, look at it tomorrow and come back to class. So I went back and I looked at Halsbury's and I could not find the Ways and Means Act. And the next day when I asked him, he smiled and said, the Ways and Means Act is that if people want to get certain evidence, they find the ways and means to get it. Now, that test is not necessarily applicable all over the world. But in India, by virtue of the 1974 decision, 1974, 1 SCC 345, we have made admissible evidence which is relevant, though the source of it is questionable. Now, this, of course, principle must be tested on two grounds. There are legislations, such as, by way of example, the Narcotics Act, NDPS Act, where illegally seized evidence will be issued from consideration. And the reason for that is because the Act has very stringent provisions and the legislature has required the highest standards to be set. The second principle was in relation to electronic evidence, section 65A and 65B of the Indian Evidence Act. In Sanjay Singh's case, 2015, though, as I will deal later, that test has been somewhat diluted now, in Sonu's case and in Mohammed Shafi's case. But the fact is that barring these exceptions in separate legislations, the source of evidence is not so relevant as long as there is relevance. There is, of course, one caveat, one clarification I must add. In criminal cases especially, we deal with a concept called the link of evidence or the chain of evidence. Now, that's the source, that is, whether the sanctity of the object or the material or the document has been obtained. That has nothing to do with the illegally obtained evidence, because illegally obtained evidence is the source from which you acquired. So you can even go and say, well, I was standing on my porch and a pigeon dropped certain government documents in my house and I'm going to use them today. And that becomes the basis. Or Sergeant Pigeon dropped the opposite side's house. And you can always, and if questioned that, whether for a Official Secret Act prosecution or for a theft prosecution, you can always try and plead Article 20 and get away with it. But from the point of view of evidence, that evidence is acceptable and there is no reason why it should be issued from consideration. We also have in Evidence Act the concept of direct and circumstantial evidence. Now, what's direct evidence? Direct evidence may be documentary, may be oral. And then we have circumstantial evidence, which is when we don't have, let's say in a murder case, we use the concept last seen together. The first time I heard it, I kept looking for this last seen together and I could not find it in the Evidence Act, except the judge before whom I said, so Mr. Luthra, is it last seen together or is it not? And for the life of me, I was a young lawyer, probably with almost less than a year at the bar. And not that I had done much hard work during my law college days, as I must confess, spending more time doing other activities rather than moot courting and others. So this last seen together is an intriguing concept. It really means that if the last seen with an individual and then the individual goes missing and the body is later found missing, then you have to show that you were not responsible, but you will only have to show once the prosecution lays down foundational facts that either you had enmity with the person, there was a motive to do away with the person, or that you spent time till the last. Many, many years ago, I'd done a case in the Delhi High Court. It was 2007. It was the case against then a Minister Shibu Soren. Now, Mr. Shibu Soren was being prosecuted at that time because his secretary had gone missing. Now, when the secretary went missing, the investigation started, the prosecution was launched, and it was a pure case of circumstantial evidence, and we did not succeed in the trial court or the High Court, but I'm told the appeal is still pending in the Supreme Court. And the entire basis was that of circumstantial evidence. The classic decision is a wonderful case argued by Mr. Ram Jethmalani way back in the 80s, Sarad Birdichand Sarda, AIR 1984 Supreme Court, 1622. It's a beautiful decision. I recommend it to all my friends. It's a wonderful decision to read. While dwelling on this issue of evidence, we must also deal with what is a little bit about documentary evidence. Documentary evidence is very important, especially in civil cases. There are mechanisms on how certain documents such as wills have to be proved. The Evidence Act provides for that. There are sort of documents which are tested, you have to bring the testing witnesses as required under the Act. There are presumptions on production of these records. So let's say the record is 30 years old, there's a presumption in that favor. If it's a record of a court or a pleading which is an old record, that's admissible in evidence. Judgments of foreign courts are admissible. It's a different matter what is the value we give to them, and I'll deal with the value a little later. But so documentary evidence can be either the production of document itself, or if it is not available, by secondary evidence, that is to say, maybe a photograph, or somebody says, I've seen the document, or I was the maker of the document, or entries in a register about the dispatch of the document, or drafts which were prepared, and then the dispatch or the receipt of the document. So there are secondary evidence which can be required. But the primary evidence is the maker of the document. Now, during evidence, and I must tell you as an appellate lawyer, I find this problematic because very often documents are produced in evidence, but you don't have a person who identifies the signature of it. And then sometimes witnesses come and try and interpret the contents of the document. If you identify the signature and the sending of the document, the contents will be 91 and 92 of the Evidence Act will apply. The difficulty is when we try and overreach, and that becomes an important issue. So as I said, 61 deal with documents. What is important now is the addition in section 65 capital A, 65 capital B, brought in by the Information Technology Act of the year 2000, which is the relevant legislation, which permits the introduction of electronic evidence. Now, what is electronic evidence? Material on a pen drive. In the old days, we used to have software. In the old days, we used to have those discs. You remember those circular discs, those big circular floppy disks as they used to be called? Material on that, a film. All of these are now, if in digital form, are electronic evidence. The test for electronic evidence was first done in Delhi itself in a classic decision called Dharamveer Khattar, because our whole case was that 65, 65A and B needs to be applied, and the question is an electronic record a document or a material object? The view was that an electronic record is a material object. Now, just to go back a little, in criminal cases, you are entitled as an accused to the statements by the police, as also you're entitled to copies of documents, but you're not entitled to copies of material objects. I mean, imagine if a gun is seized in a case and somebody says, please supply a copy of the gun. You're not going to get it. You're going to see it visually. You can inspect it. You can examine it. You can get an expert subject to permission of court, but you're not going to get copies. What you may get is a copy of the sketch of the gun, but that's about it. So you had, as I said, the electronic evidence, and electronic evidence was established. It was deemed to be documentary evidence interpreted, though the provisions are very clear, but it was interpreted nevertheless. In terms of the amendment to the penal code also, it's very clear, and the presumptions. And then you had a number of Supreme Court decisions. First was P.V. Anwar versus Bashir. That was Justice's beautiful decision, which said, if the electronic evidence is not tested in terms of 65A and 65B, please issue it from consideration. Sanjay Singh in 2015, 3 judges went a little further. They took a view that you not only have to produce the electronic evidence, but you also have to produce the material or the equipment on which it is recorded. So, for example, I have a recording on a pen drive or on a recording device or on a video camera. I will have to produce the video camera because it is the marriage of the two that establishes that this is the original document. I must tell you, when we did the Tehelka case, we had a lot of issues on this because way back in the year 2000, 2001, 99, 2000, we had the Commission of Inquiry, the Act was coming in at that time. And it was very interesting as to how we had to establish the veracity of the video recorded files in that Commission of Inquiry, because there were a number of video recorded files that were done, and how to prove the original. The law was, of course, a little grey. Since then, it's become clear. Unfortunately, there have been two dilutions. one of the first dilutions was that the honorable judge who wrote the Anwar judgment, and Sanjay Singh, has actually come out with an article trying to correct his own and dilute his own view. That's a very unusual thing that has happened, but it's the reality of law. So a sitting Supreme Court judge has sought to dilute his own decision, his own precedent. The second dilution happened in Sonu, which I had argued, and what we had said was that electronic evidence cannot be taken into consideration; it must be eschewed. Meanwhile, of course, the court had started getting concerned. That judgment of that article had also come out of the judge, essentially diluting his own judgment. And in Sonu's case, they said, if you don't take an objection at the first round, you can't take an objection later, which is, well, it's the law of the country today, so I can't really object. And then, of course, two judges in Shafi Muhammad, like there were two judges in Sonu, further dilute P. Anwar, and that is the current state of the law. It's a peculiar state of the law, but that's the way it is today. I must also deal with here for a moment with the issue of burden of proof and onus of proof. So while we're dealing with Evidence Act, the burden of proof never shifts. So if you remember in civil cases, you had the onus of proof, which is OPP. It may be onus of proof on parties after issues are framed, or onus of proof on the defendant, or onus of proof on the plaintiff. So that is the onus of proof. Who will prove? In criminal cases, the onus is on the prosecution, but it sometimes shifts to the accused. For example, if you prove the facts of murder, then to prove general defenses or alibi will be on the defense, will on the accused. Or in a case of breach of trust, if the entrustment is proved and the return is not proved, then the onus shifts on the accused. That's AR 1960 Supreme Court, Kishan Kumar Khanna's case, Kishan Kumar Khanna versus Union of India, where moment you prove that you had entrusted certain material or money to a person, that person is not returned it on demand, then the onus shifts on the recipient of the money, the accused, to show that the money was utilized for an official purpose or that the money was returned back. And that is the shifting of the onus of proof. So the onus will keep shifting, but the burden of proof, as I said, never shifts. Under the Evidence Act, we have, as I said earlier, many important provisions of relevancy. We use colloquially as lawyers the hearsay rule. We've all heard of hearsay. You will not find the word in the Evidence Act, but then you won't even file hostile witnesses in the Evidence Act. So you have the hearsay rule, which says, what if I am relating what A says to B. If A says something to B, my version of what A told me can't be proved by me, it's hearsay, but there are certain exceptions to this rule. Amongst the exceptions are what is called Section 6, the res geste provision, res geste from English law, but introduced in Indian law. So facts forming part of a transaction, which may relate to proximity of time, the test being of proximity of time, place, continuity of action, and continuity of purpose or object. So for example, if I have a conversation with somebody and there is a contemporaneous record, video recording or oral recording made of it, or tape recording made of it, then that will be protected under Section 6. That's not hit by the hearsay rule, and that is classical decision R.M. Malkani, 1973, 1 SCC 471 mentions this fact. Experts, Section 45. They're speaking about their understanding. Then you have Section 32 and 33. So where a witness is deceased, not found, that in those circumstances, in Section 32 deals with people who have spoken a dying declaration by way of example. So dying declaration is introduced under 32, and similarly, people who can't be found or are dead, that evidence can be introduced, and there are exceptions to the hearsay rule. This chapter in relevancy is rather large, so I'm going to only touch upon certain provisions because as we do realize that time is limited. And if I continue on this, we could go on for hour and hours. And I understand from my days as a teacher that 45 minutes is the maximum time to which a person's concentration remains. So I try and keep my talks to up to 45 minutes. Section 7 is an interesting provision. We deal with this in practice, but what does it really say? It talks about facts which occasion, cause, or effect of facts in issue. Facts which are the occasion, cause, or effect of facts in issue. So, for example, the illustration is beautiful. Marks on the ground after an incident of violence, or if somebody is robbed, then the fact that the person who was robbed went to the bazaar, made a public announcement that I have a lot of money in my home or I'm carrying a lot of money, will become protected or brought in under Section 7. We also have Section 8, the motive or preparation, previous or subsequent conduct. You may recall I mentioned circumstantial evidence. Motive is a very, very important aspect in circumstantial evidence cases. There's no importance in direct evidence cases. We have one of our friends who's decided to make us listen to the traffic sounds, so they'll have to do something about that. Now, Section 8 also became very important in the classic Parliament attack case. You all know the principle of Section 27 of the Evidence Act, that if a material object is recovered, then that becomes very important for consideration. And the mere thing that a fact or an information is recovered is not good enough. And that test of Palaka Narayan Swami's Kotaya's case, Pulukara Kotaya's case, has been accepted via 1947 Privy Council till date. But Section 8 become important because we have now what are known as pointing out memos. So if a witness is procured or an accused is procured a SIM card from a certain place, the SIM card has been recovered by the police separately. But the fact that this is the place they've found the SIM card, or this is the place the SIM card was procured from, is admissible now in terms of Section 8, post in terms of the Navjot Sandhu's case. Navjot Sandhu, of course, has been diluted in the context of electronic evidence, but that's a separate issue, but it remains good law in terms of Section 8. Section 9 of the Evidence Act talks about facts necessary to explain or introduce facts. One of the classic use of Section 9 is TIPs, test identification periods, or let's say there is a mob going on a street. Now, to determine whether A, who's leading the mob, was part of the unlawful assembly or that there was an unlawful assembly, the sounds made by that mob, the cries, the shouting, if recorded, if heard, become admissible under this provision. There is also Section 10 of the Evidence Act, which deals with conspiracy cases, and that talks about material which is considered, so material against one conspirator can be used against the others. There are other provisions dealing with Section 15, etc., 16, dealing with whether acts are accidental or intentional. So one of the classic cases, supposing a person is committing forgery. So one of the things we do in forgery cases is a falsification of record. We see, does the person have past antecedents? Is this one wrong entry or multiple wrong entries? The moment there are multiple wrong entries, you can say it's a case of falsification of diaries or records or financial records. But if there's one entry, the person can say, look, it was not an intentional act. I'm covered under Section 15 of the Evidence Act. We have a large chapter. We have large sections on admissions and confessions. Admissions and confessions are equally important to civil and criminal cases. In civil cases, very much more so, because admissions and pleadings can result in a judgment under Order 12, Rule 6 of the CPC. But these admissions have to be seen in the context that they are made. So, for example, now even admissions in bail applications, if you accept a certain point in a bail application, that's also being held to be a material circumstance in determining your guilt or innocence. Beyond the sectional admission, Section 17 onwards to 22A, we have the sections on confession, which is Section 24 to Section 30. Section 30 deals, of course, with the co-accused confession, which is not acceptable. That's been settled recently. And then you have the other provisions, such as 24, that a confession before a police officer is not admissible. In the context of criminal cases, departmental proceedings, however, statement before officers of departments who are not police officers have been acceptable and admitted, and the bar only applies to police officers. We also have an interesting section here, which is section 27, which is recoveries made at the instance of an accused which are accepted and which are considered valid. The rest of the statements to be issued. In North India, unfortunately, there is a practice, at least in most of the North Indian states, that if a person makes what we call a disclosure statement, a section 27 statement, that section 27 statement will be admissible in its entirety. In the southern states, and even in Maharashtra, central and southern states, they only excerpt the particular line from that confessional statement, which is related to the recovery, and the rest, though it may be in the nature of a confession, but only the sentence or the couple of sentences which relate to recoveries are accepted and excerpted, and only that is treated as the exhibited material, nothing else. The rest is not even considered, though they may be on record. In fact, currently there is a petition pending in the Supreme Court that these rules of how evidence is to be kept recorded for the benefit of courts and lawyers alike must now be streamlined all over India, and that matter is under consideration. We cannot complete a discussion of the rules of evidence without considering the relevancy of prior decisions. Are civil judgments binding on criminal cases or criminal judgments binding on civil cases? The answer lies in section 40 to section 43 of the Evidence Act. So there are judgments in rem and judgments in personam, judgments in the admiralty jurisdiction, that is shipping, matrimonial, that is divorce, and or marriages, and probate are judgments in rem. The rest are judgments in personam, so they can't be proved under 4041. They have to be seen otherwise. They are relevant, but they're not directly on point. They're not judgments in rem. We must also consider that we have all, there are, if you go back to the 70s, there was a point of time when people believed that if on a certain issue, a civil judgment came, that would be binding on a criminal court. Now, this principle was actually not accepted as far back in 1956 in M.S. Sharif's case, where they said criminal cases will have precedent and judgments are not binding. And that principle has again been laid down on a number of occasions in 2002 in KG Prevention.
How can I resolve that?
In KG Prevention's case,
We have to follow.
if I may continue, one of the decisions which I would recommend to you is, and I may say I'm a little partial to it because not for any other reason, but because it carries the entire law on these sections. It carries the law on section 40 to 43, which is Arvind Kejriwal versus Arun Jaitley, Justice P.S. Seji's decision. It's an interesting decision, carries the entire body of law on the subject. Having said that, there is also a concept of issue stop. So, by way of example, judgments, if the issues in both cases are the same, in those and only those cases, apart from the 40 to 43 rule, civil judgments will be binding. So, for example, if you get an exoneration in an adjudicatory proceeding in a special legislation, be it the PMLA, be it with the Customs Act, or be it the the Excise Act or Income Tax Act, in all such cases, on the principle of issue estoppel, you are entitled to get a dropping of the criminal proceedings, and there are two important decisions. One of the decisions is Radheshyam Kejriwal 2011, and the other one is Videocon. Radheshyam Kejriwal, interestingly, relies on some Delhi High Court decisions and a decision of Justice Sikri, which is a beautifully written decision. There are, you see, if we start discussing this further in Evidence Act, I think I will never, as I said earlier, I will never end. But I'm just going to touch upon a few more issues before I wind up, which I think are important from the practitioner's guide. For example, Confessions of a co-accused can't be considered. We have a 2018 decision, SCC 27, Surinder Kumar Khanna. Haricharan Kurmi is the classic decision, AR 64, Supreme Court 1184. But please note, there are legislation such as TADA used to be, which allows these confessions to be taken. There are other legislation which say that if a statement is recorded in the presence of another accused, that statement is admissible evidence. So those exceptions apart, ordinarily, confessions of co-accused are not to be considered. Scientists and scientific tests. How do you deal with scientific tests and expert witnesses? Selvi's is a classic decision which says these lie detection and these other tests are only tools for gathering material during investigation. They have no scientific veracity. However, in a recent 2019 decision, the Supreme Court in Ritesh Sinha case, which went from Delhi, has now accepted the principle that samples can be taken and even devised a mechanism in the absence of legislation. Experts are very important to a practitioner's case. If you look at the principle on expert, section 45 and 45A are the new IT experts that will be brought in. But section 45 especially, experts' evidence is opinion evidence. It's not supposed to be given a very high level of credibility. But practically, we all know that when it comes to handwriting evidence or similar other scientific evidence, the expert's evidence is often the fulcrum on which cases revolve. Of course, in the case of medical versus ocular evidence, if the oral evidence is very clear and medical evidence has discrepancies, courts often disregard the medical over the ocular, though there is another test in Mohanlal's case, which is a very interesting case, and that test is that if the medical evidence trounces the ocular evidence, then you can actually disbelieve the oral evidence, the witnesses. So those will be cases like if a person is supposed to have been shot by a gun, but there are no bullet injuries, and he's died of a heart attack. So there, even if a person claims, the oral witness, that he was shot or he was stabbed or he was, poked with spears, and there are no medical injuries commensurate with that. That is the reason cross-examination often takes place relying on the expert evidence to say that the oral evidence, the witnesses, the eyewitnesses, did not see the occurrence or were not present, and they put up a state of facts, a state of affairs, which actually did not exist, and therefore they are lying. But cross-examination of an expert is not an easy job. The reason is you're dealing with somebody who is a domain expert. As lawyers, we are generalists, we are not domain experts. So there has to be a deep understanding of the field, a study of the material on the subject, a study of the nuances, a study of the reports, the medical reports, if they are available, the weapons, if any. All of these need to be analyzed very, very carefully. And I would recommend, it's always a good thing to go and reach out to an expert in the field, whether in forensics or somebody who's done either a person who's dealt with forensic or weaponry, or even a doctor who's done a lot of postmortems. Doctors by and large who do postmortems are not physically cutting up the bodies of the deceased. It's really the helper who does it. And therefore, that is another line where you can try and trip them up as to when and how and the timing, but that's only part of it. Normally, courts tend to believe experts, whether it be handwriting or medical experts, and they take their word as the gospel truth. One of the cases which I enjoyed, which has now been, the trial court had convicted, but the High Court is acquitted in that case, is that famous case of Sohail Ilyasi. We were faced with a medical board ordered by the High Court, which had come up with a report and declared it to be a case of murder, 5 very eminent doctors. So the problem was, and I had cross-examined that witness, and we were concerned how to come out with this expert. The gentleman had written a number of books. when we scrutinized his evidence time and again, we started finding that there were discrepancies between what he had said in his own book. So we started questioning him first on his own book, then on Modi's medical jurisprudence, fixed him on the fact that what was stated in Modi was acceptable to him, what was stated in his textbook was acceptable to him. He had written many textbooks, he may have forgotten the ones he had written. And as a result of this, we were able to demolish the evidence. We also had to establish that the 4 other doctors had given a biased opinion, and that could only be done by showing that they were all directly or indirectly connected to him. But once we questioned the veracity of the medical board's findings based on established literature, and we were able to put that literature to the doctor, we were in a position where we were safe. The last area today that I want to dwell upon is the recording of evidence in court. There are the most important test for a practitioner is evidence in chief and cross-examination, because that is the mechanism of determining whether truth or not. That's part of the open court principle. Now, why does this gain so much importance? It gains importance because both at the time of admissibility, admitting evidence, relevancy, the tests of admissibility, relevancy are all crucial at this test. And the practitioner has to approach it from a very large perspective. All over the world, the most sought after lawyers are the trial court original side lawyers. In India. That used to be the position, but now I think the focus has changed to appellate courts more than it should. What is important here is a complete understanding of your facts, a determination of the intersect contradictions between various witnesses, an analysis of the statement the person has made in the past, whether there are different contradictory statements, either in that file or elsewhere, in other collateral proceedings, and the ability of lawyers to record objections at the earliest. It's very important for lawyers to record objections, though unfortunately the Supreme Court has come down to the principle that these objections must be decided at the end of the trial, but that's a reality of life. Now, what I would recommend really is that when we're dealing with this, we must be very, very sensitive in terms of the questions not to be asked. This term is used very colloquially, but very often a fatal question is asked which creates a liability. Early on in my career, I remember there was a copyright case, and in asking one of the questions, I recall that I created a position which took me weeks of cross-examining the other witnesses to try and come out of, and eventually, of course, the matter got resolved, so we never got to know the effect of that question. It got settled, as most copyright criminal prosecutions do, but that became a very important issue. We must also consider that there is examination in chief, cross-examination, and re-examination, and then cross-examination, that is cross-examination based on re-examination. Increasingly, we find that examination in chief contains irrelevancies, things which should not be there, objections not raised. And this is a question I'm asked as an appellate court lawyer all the time. Then again, we find that gaps between various people's testimonies are not adequately exploited. Contradiction with contemporaneous records is not made, the contradictions are not brought out, the improvements are not adequately brought out in terms of Tehsildar Singh's case. And also, there are cases when there are multiple accused. And recent case which I had argued at the final stage, I found there were multiple accused, which is a normal problem, which happens in many cases. And I ended up having to deal with troublesome cross-examination done by another accused who had thrown the burden in my lap, my client's lap. Unfortunately, the trial was at the final argument stage, and at that stage, the cross-examination done by another accused leading to statements against me had never been questioned, though legitimately, there's a 1962 judgment, you have a right to cross-examine if another co-accused gets a bad answer against you. So today, friends, I'm going to leave you with a flavor of the subject. There's a lot more to be said. The Evidence Act is the glue that holds together all procedural and substantive laws. The fact that as a community, there is not adequate attention paid to Evidence Act and evidence, the study of evidence, is now increasingly apparent in what is coming up to the appellate courts. So it is time for us to begin an exercise to appreciate this beautiful legislation, which can mean the difference between victory and loss, innocence is guilt. Thank you very much.
Sir, thank you very much, sir. And I have few questions, sir, which has been put in the chat box. So one of the very crucial question which has come up is that, as you has stated, a basic principle of criminal law, that the prosecution has to discharge its burden to prove beyond reasonable doubt. But how much does it applies in the POXO cases? Am I supposed to discharge my burden, the accused?
Unfortunately, if you see the amendments to the POXO Act, if the sexual offense is proved, if the act is proved, then the burden to prove innocence, burden beyond reasonable doubt, is now on the accused. There's a specific provision, I don't recall it, but you can indicate that provision, that burden, I think 2930 should be the provisions, that's shifted. And this reverse burden, not just with preponderance of probabilities, but with proof beyond reasonable doubt, is being increasingly used in a number of statutes. And that is becoming a practitioner's nightmare, and also for judges. It becomes difficult in such cases to consider if, even on the most basic of evidence, they can convict. That's not necessarily the best state of affairs for a society governed by the rule of law.
So the another practical question which has come up here is, does that during the examination in chief, certain documents are marked or exhibited? Does that mean that if the objection is not taken for marking or exhibiting of certain document, that will be taken as it is proved?
Look, Sonu's case creates a problem in this. Earlier, there was no issue. The document had to be tested on its veracity. But according to me, Sonu's case has created an issue, and that will have to be dealt with, though it's only a 2-judges bench. In my view, a material which is not otherwise admissible does not become admissible merely because it has been exhibited or marked. Because identification of a document, as you rightly said, Mr. Verma, you're a great expert yourself. Identification of document by marking or exhibiting does not mean proof. For that, we have to follow the principles of the evidence.
Thank you. So the last question is, sir, would the expert's cross-examination be treated as dying declaration if the expert dies after the recording of chief?
No. No. But I can tell you, on dying declaration, since you've asked, I would recommend you read the Nirbhay case. We had a very interesting thing. I'd done that in the Supreme Court, Dhyan had done that in the High Court, Madhav Khurana and Dhyan, and in the trial court. And in that case, what was very interesting was there was a dying declaration by the lady merely by pointing out. At that stage, she only did by signs. She was not able to speak. Even that's been accepted as valid.
The most of the time, as you have Anwar PB's judgment and other judgments, you have referred Sonu's judgment also. Most of the time, it's seen that the 65B is not produced at the initial stage, but later on it is coming when the witness is coming and is bringing 65B certificate. What is your view on this kind of practice?
According to me, it is contrary to the provision of the Act, but Mohammed Shafi's case allows that. In fact, Shafi's case has opened up a Pandora's box, according to me. Look, we have to understand electronic evidence can be generated very easily. The certification and Sanjay Singh's principle of seizure of the original becomes very important, because that becomes the test that it actually exists in the form it does. Because the ability to manipulate such evidence is so easy. It is horrifyingly scary how electronic evidence can be generated or manipulated. So therefore, my view is the production of a 65B at a later stage with no 65B originally means that the material ought to be eschewed from consideration. But as I said, after Mohammed Shafi, that's not going to be the position.
Thank you very much, sir. We have so many questions, but they are related to any other subjects also. I do not wish to keep this session for long, because we're already almost an hour. Thank you very much. Thank you very much, all the participants. And I also would like to thank International Bridges to Justice. And I wanted to inform you that when International Bridges to Justice started in India in 2008, it was the Sidharth Luthra sir who was big support to this organization. And the aim was to have an effective defense, and all the lawyers should be mentors. And that is the vision we are having, and we started this series. Thank you very much, all of you. Thank you, sir. Thanks a lot.
Thank you, sir. Thank you.